Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Hi, and welcome to the Southwest Florida Real Estate Update. I'm Michael York of the York Real Estate Group, and today we're joined by our host, Jim York, and his guest, Don Ross Jr., President of Ross Title and Escrow.
Thank you, Michael, for the introduction. Well, Donald Ross, you're welcome back to the show again.
Thank you, Jim. Appreciate it.
So the people that haven't seen the show, which I'm sure there's just a few, okay? Tell us a little bit about yourself.
I'm a local attorney. I have a degree in taxation, been a member of the bar since 1981. I focus in real estate law. I own Ross Title and Escrow. I'm one of the owners at Downing Fry Realty. I've been their counsel for about 25 years. We have about 7 employees at the title company, Ross Title and Escrow, right across from Pastrami Dan's on 41. Most of my people have been with me for a very long time, 30 years, 20 years, 10 years. They're actually related, a lot of them, so do quite a few closings and hopefully do a fairly good job.
Do a great job. I know our clients are very happy with you.
Thank you, Jim.
You return calls yourself and your staff. So, Don, we're doing a series, we've been doing them for the last couple of months here about contracts, which we've talked over the years about contracts, but it's been nice that we've been putting up on the screen a picture of the contract of what we're talking about. And today the first part of our show, we're going to talk about mortgage contingencies, which is can be a problem or not be a problem, right?
They're always a problem. Well, we were talking about this beforehand. Probably half our transactions are cash, so realtors may or may not be as familiar with the contingency because they just don't see as many of them. Some realtors, their practice might be 80% cash.
That's true.
So when one pops up, they really don't know how to handle it. I generally, it's paragraph 4 of the NABOR contract. The buyer has 5 days to apply for the mortgage. That's important to show they made a diligent, good faith effort to get the mortgage, which is a requirement of the contract. And then they have 30, 45 days to waive the financing contingency should they decide to do so. Now, the problems I see with the NABOR one, and I'm just talking about NABOR at this point.
Let's bring it up on the screen, okay?
Sure.
For a minute here while we're talking, okay?
Sure.
Go on.
Well, I mean, a lot of realtors are buyers, because I get the for sale by owners as well. They don't put in the interest rate. And there is no default interest rate in the Naples Board of Realtors contract. So you want to ask your buyer, what interest rate can you afford? I mean, the whole point of the paragraph is to protect the buyer's deposit should they fail to get the mortgage described in that contract. So make sure this is something that they can afford. I mean, it's there to protect them, so get the information from them. Fill in all the blanks, because that forces you to go over it with the buyer. There's a block you check if it's conventional or if it's FHA. It's deemed to be conventional if you don't check anything, but it's always good to do it on purpose than by accident.
And on that interest rate, it's not to exceed a certain amount, right? So explain that a little bit.
Well,
if you put 5% in, and if they ended up getting a 6% or a 4%, how's
well,
it?
I mean, the more dramatic example, let's say it was 5%, 80% mortgage, 30-year fixed loan. And the client had already sat with the loan officer, and they looked at what they earned, and they looked at what their credit card debt and their car loans were and everything else, and they said, this is what the payment would be at 5% or 6%, at 7%. And then the buyers, knowing their own financial situation, can evaluate it and say, yes, we can afford this much. And if it goes above that, they can't afford it. So it does two things. It protects the deposit, and it gives the buyer some degree of control over their future finances. We can budget for this, but anything over than that is going to be too difficult for us.
And so the next part in this contract is how long they have to apply for a mortgage.
Well, they have 30 days to apply. They have 5 days to apply for it, and 45 days to waive the financing contingency. Now, there is another provision in the contract that if you have a contract that's closing in 2 or 3 weeks, that everything gets pro rata reduced. So the 45 days to waive gets reduced. The 5 days would probably stay the same. It doesn't really get into detail how you calculate that, but it is reduced. And the 5 days, I point that out because if you're signing something on a Friday, are you, as a practical matter, going to be able to get to it, by the following Wednesday? And give yourself an extra day or two if you're planning to meet with your loan officer on the following Thursday or Friday, which would be beyond the 5 days.
Right.
So point that out to the buyer. You don't want the buyer waiting until 2 weeks before closing.
No, you don't.
And then the seller could potentially claim that the buyer did not make a good faith effort to get that loan and try to claim the deposit, even when the buyer's turned down.
Yeah, and the mortgage person really can't start entering that until he has the contract. So I always tell him that I'll send a contract, or you should send a contract to the mortgage person, because that can, postpone things. They might. Some people don't realize that.
Right.
They think they've already applied.
You're absolutely right. I would say the next big point is this misunderstanding on waiver of the finance contingency. It seems, and I could be wrong, but it just seems that there's a number of people out there who will tell their buyers, you need to waive this.
Right.
Which I never do.
I know you. I know.
The way I explain it to my clients, my buyers, is the waiver is a personal business decision on their part. They know how much money they have in the bank. They know if they have extra money, that if they don't get the mortgage, they can still pay for the property. They know, they should know, they're in a better position to know whether or not they're going to get the loan or not. I mean, they know what they make. If you make $1 million, you should be able to get a $200,000 loan, unless somebody's brain dead. You should be able to get it. So they're in a better position to evaluate whether or not they should waive the financing contingency or not. And I get a lot of realtors asking me, is the buyer required to waive the contingency? And I say, no.
No, they're not.
No.
The seller might want them to do that.
The seller might. All that 45-day period does is on day 46, the seller has the right to terminate and the buyer has the right to terminate. The seller could terminate if they had another buyer for more money. Or the buyer might have been a living nightmare in the inspection process. Or they might have too little down as a deposit and the seller's getting nervous that they're going to miss the season. There could be a whole bunch of reasons why the seller might want to terminate after the 45-day period.
So the buyer would have to have a letter from the bank saying they couldn't get a loan after that 45 days to get their money back, their deposit back.
Well, there's two parts. One is an equal opportunity letter of adverse determination showing that the buyer either personally doesn't qualify to get the loan described in that contract, or the property doesn't qualify. Okay, which potentially could get into whether it appraises at the correct amount. In some situations, we argue if there's too many investors in a condominium, if they don't have adequate reserves in a condominium, and the lender will not approve the property because of that. And that's something that lawyers debate, but generally I go in favor of, if there aren't enough reserves, that's a property-related condition.
So let's just talk about that appraisal, okay? So, we're in the contingency period, okay? The appraisal comes in less than what they paid for it. What are everybody's options at that point? Explain that.
Well, the seller has the right to terminate. The buyer, if they get this letter of adverse credit determination, it usually has these little blocks, and the loan officer checks off which particular explanation applies. The buyer could have inadequate cash to close. The buyer could have excessive debt load. The property appraisal is too low. So if they check off anything that relates to the buyer's personal finances or the condition of the property, like the appraisal, the buyer submits that and attempts to terminate the contract.
Or the seller can possibly come down in their price to meet the...
They could.
And make up the difference, right?
They could. In the beginning part of the process, if I'm representing a buyer and we have a financing contingency, we might get into a discussion on appraisals and how they taught us in real estate school that appraisals are an art, not a science. And it's not an exact number. There could be a 10% differential between what the appraisal says and what it really is worth. And then you also get into whether or not this is going to be the buyer's retirement home, and do they really, really love it, and is that 10% a deal breaker? I mean, this is where you're going to spend your last dying breath living in this property. You know, what value would you ascribe to that joy in living in this property on the beach or wherever it might be, to, you know, that 10% lower appraisal?
Right.
You know, how much of it, how important is that to you, you know, realistically speaking? So all that does after 45 days is give both parties additional rights. Nobody's required to do anything. And with the buyers, I say, you got to decide whether you're going to put at risk losing the deal with the seller terminating, or losing your deposit if your lender does not come through with a loan and you don't have backup cash. You make the decision. You have your own degree of risk tolerance, and you have a better knowledge than I do of your financial situation. And the last thing you need is to have, say, Jim York telling the buyer, go ahead, you're safe, waive it, and then it blow up, and then they blame you.
No, we'd never do that. So we've listened to you too many times. Okay. So Don.
Sure.
Well, knock on wood we have. So Don, we're going to take a little short break, and we're going to come back and we're going to talk about inspections and what you can do when you have an inspection and what you can't do. We'll be right back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.
Welcome back. Well, Don, part 2 of the show, second half, we're going to talk about inspections. And I think, a couple of things that we have in a contract is the mortgage contingency that's always kind of a problem or not a problem. And inspections, I think, are the biggest problem because nobody understands what's covered, what's not covered, and when you have to respond to what and whatever. So why don't you just start where you want to start?
Well, I guess with the NABOR contract again, just the time frame, the buyer has 15 days to conduct their inspections. They have 5 days after that to ask the seller to fix something, remediate it, or ask for a credit. Both of those options, they have to give the inspection report. With the credit, they have to give an estimate, so it can't be a made-up number.
That's right.
You can't just say $5,000 for a light bulb. It's got to be an actual estimate from a licensed company to do whatever the defect is.
But the problem there is, I just ran across this with one of our deals. Okay, so the inspector that we use, which he has a master's in inspection. Right. He was 4 days out, 5 days out. When he does the inspection, we get it that night. Right. So, but there were. I'm not saying quite a few. There was some stuff on the thing, and they're just, 15 days doesn't give you a lot of time to get a contractor out there to look at it and give you an estimate. In certain cases, I'm not saying in all cases. Right. So in that case, that maybe there wasn't enough time because you might need a plumber, an air conditioner, or a electrician, you do an addendum to try and get a longer? You could do an amendment.
A lot of times, and that's a great point, you'll get the initial inspection report.
Right.
And that report will recommend further inspections.
Right, it does.
Whether it's an HVAC person or a roofer or a structural engineer, and the burden of those additional inspections is on the buyer. So if you get something like that, you would want an amendment extending the inspection period for whatever the appropriate period of time is. And in that situation, I would recommend giving a copy of the report to the listing agent so
they understand
know
what
that
it is. Okay.
you're not making it up. I mean,
Okay.
if this is true, not only are you showing that it's true and you're not just trying to delay,
Right.
you're putting a certain burden on the owner, because if it's anything significant, now the owner and the listing agent has an obligation to disclose that
Going
latent
forward.
material
Right.
defect, if it is one of those, to the next buyer if this deal falls apart. So, there's a lot of psychology with the whole inspection process. There's a building of trust that really just starts with the seller's disclosure, honestly, and the rapport between the agents, and sometimes you have one experience like yourself who's very experienced, then you have another agent who's not experienced at all. They might have just been licensed a few months ago, and unfortunately, human nature being the way it is, when you're inexperienced with almost anything,
Right.
many of us tend to get belligerent and rather than admit that we just don't know how this works, and which is unfortunate because we all started knowing nothing,
That's true.
and we all came from the same place. So it's not, bad to say, Mr. York, I'm new in the real estate business and I don't understand this. Can you help me out? It would go a lot easier. The rapport between you and the listing agent would be better in that situation.
Yeah,
and
you gotta
would
work
make
together.
An honest effort to teach the man or lady, how the contract works. But you got your 15 days, and you might have an inspection on the 15th day. But by having 5 more days to make your election, it gives them time to type up the report,
That's right.
and then have you read the contract and look at what's defined as defective, which starts at the bottom of page 5 and goes to the top of page 6.
Exactly.
And this and the problem last season was permits. That's under the general repair items, permits. And they weren't able to determine within the 15 days in many cases whether there were open permits. Permits that weren't properly CO'd or expired or void, and you have to do further investigation. So I saw a number of amendments where that part of the inspection process was extended. They were given more time to find out about permits. Not everything, just that one thing that was holding you back.
Yeah, and he can bring this up on the screen so people can read it while we're talking for a few seconds here.
Sure.
But the permits is a big problem.
It's not a title issue. It
Right.
doesn't affect whether the lender's going to loan or not, unless the lender knows that it's something that might affect the value of the property, the structural integrity, or the safety of the property. So if people think permits is the same as a title defect, they're not.
No.
It's just they put it in this particular paragraph of the contract rather than its own paragraph, which you see in the statewide contract. So you got this time period to do it. They have a definition. And if you're sitting with your buyer, it's nice to go through the bottom of page 5 and the top of page 6 and say, this is what is considered defective.
That's right.
Now, what's defective under the contract isn't always what a common sense, normal human being would think is defective. See, it's what the contract says is defective.
That's right.
It could be ridiculous, but the
Right.
contract says it's defective. It's not. You never use your own common sense when you're talking about the law, because you might make a mistake. So you're pointing this out to the buyer, and if you're representing a buyer and they know this is defective, you can strategically say, well, we're going to ask for more than we're entitled to. If you don't ask, you don't get. Words
true.
that I was raised by.
Right.
And you ask nicely, pretty please, you might get it. Some people are actually nice out there. They might want you to have a brand new whatever, and you might get it. So ask for it, and whatever you get, your buyer will think you're brilliant because you got them something they weren't entitled to. And it's how you handle it, it's how you prepare your buyer, it's how you prepare your seller. Part of this, you get the definition of defective items, and then it goes on to say, it has it on page 6, 2/3 of the way down page 6, it's line 298, if it's going up on the screen. There's a definition for working condition, and there's a definition for cosmetic. The equipment and so forth has to be in working condition. If it's a cosmetic issue, the seller doesn't have to do a thing about it. So cosmetic is pretty important. Working condition is pretty important.
You know, like pavers that are uneven or cracked tile in the roof, it's not leaking, that's cosmetic.
That's cosmetic.
People don't understand. They think you got to get whole new tiles. But
I had a conversation with the owner of a major inspection company in this town, and he's a general contractor from Connecticut. I won't say his name. And two questions I asked, we were having coffee, you know, what's with the HVAC system not meeting the manufacturing specifications for cooling differential?
right.
What is that? Please explain it to me. And he told me, and I'm not a contractor, so
Right.
this is just what I was told at breakfast. He says, a lot of times, Don, it's a maintenance issue. They might have to adjust the fan speed. They don't disassemble the air conditioner to see if there's a leaky coil or if it's just the fan. If it tends to be a newer air conditioner, odds are it's the fan, and you can just tweak it, and it's not a big deal. And then my other question, which I see all the time, are the tiles. I said, are tiles in and of themselves, do they serve a function? What do they do other than look nice? Says, really, they're more decorative, in his opinion. It's not really discussed in the contract. The one practical thing they do is they extend the roof, the lifespan of the underlayment by keeping it out of the sun. It'd be like parking your car in a garage. The paint job will last long because it's not in direct sunlight all the time. So cosmetic does get into limited roof life as cosmetic. If the roof is 25 years old, has curling and cracked tiles, it's fine as long as it's not leaking and as long as it's structurally sound. Just because a roofing company tells a buyer you need a new roof doesn't mean the contract says that's a problem. Okay, the inspection company might be saying you need a new roof because this one's really, really old and it's about to go. Well, it's not gone at this point, therefore it's okay. Chris Mitchell, who we do seminars with, he's an insurance agent. His company might say you need a new roof because you need at least 5 years of useful life on the roof to qualify for insurance. That's not covered in this contract. The contract says as long as the roof is not leaking and it's structurally sound, it's fine. It's cosmetic. Cracked tiles is not a problem. Torn or missing screens is not a problem. That, to me, flies in the face of common sense. A missing screen is not going to keep mosquitoes out.
Right.
So it's not working in the manner it was designed to work. Sliders I get a lot of. You get a lot of reports that say the sliders are difficult to open and they should be serviced. Is that working condition or cosmetic? And to me, it's a matter of degree. If a 90-pound lady has some degree of difficulty in opening a slider, say 10% difficulty, it's probably working condition. If you or I exert all our strength and barely budge the door, it's not working condition. So it's a slope. It's a matter of degree, and it's deliberately flexible so that it can accommodate unforeseen factual situations. There's always something new. The contract is deliberately not specific in many areas because it has to be a flexible, stretchable document to cover all these different weird factual situations. Otherwise, it would just fall apart.
Well, Don, you've covered a lot, and we only have about 1 minute left in our show here, but I'd like you to touch base on if you have a defective item, like an air conditioner, what are they entitled to?
It's the bottom of page 6.
Right.
It's fair market value of the item if it were in working condition. So if the air conditioner is 10 years old and it's not working correctly, the most the buyer would be entitled to, the most the buyer would be able to use as justification to terminate the contract would be, what is the value of a 10-year-old air conditioner if it were working correctly? What would Jim York pay for a 10-year-old air conditioner? I wouldn't pay anything for a 10-year-old air conditioner. But if you have 5 days after the seller says no to something that's legitimately defective, and it has to be legitimately defective for the buyer to cancel and get their money back. the seller might argue that's not legitimately defective. So I'll usually recommend to the seller that if it's a 10-year-old air conditioner and there's a leaky coil, offer them something, because you can always get some buyer who'll get some value for it just because of scrap metal.
Right,
Could be copper and whatnot in there. There could be parts that could be recycled. Who knows? They'll come up with something. So be safe and offer something.
Yeah, so that basically covers, it'd be the air conditioner, washer and dryer, refrigerator, anything
It covers everything.
Right.
And what we really didn't get into, and I know we don't have any time, is there's a lot of psychology in this, and
Right.
The seller has 10 days to respond, and they'll bring in their own people and double check the buyer's inspection report, and how people treat each other
Right.
and how you ask really has a huge role in the success in getting what you want.
It's the truth. If you're all working together for a common cause, you can put a deal together. But if one person's difficult, it's tough.
And sometimes it's just because they're new and they're afraid to say, I don't know.
Isn't that the truth? I mean, we run across it a lot because there is a lot of new agents and everybody's got to learn. But
well, I'll get realtors and I'll say, if there's a particular situation and they know the other realtor's new, I'll recommend, why don't you say to the other realtor, this exact same thing happened to me when I started, and I didn't know anything about it, and boy, did I get nailed over this.
Right.
He said, but they didn't, Don. I said, well, yeah, but you don't attack the person for being new.
right.
You try to say, I went through that too, so they don't get so adversarial.
Well, Don, thanks for coming on
You're
the
welcome.
show.
Thanks for having me, Jim. Appreciate it.
Looking forward to next month seeing you after your vacation, wherever you're going. Okay. Thank you for
Wherever
tuning
that
in,
is.
and we'll see you next month. Thank you.